Welcome. My name is Jorge Oben, and I'm a partner with Procopio in Washington, D.C. Thank you for joining us today for a Washington, D.C. update on the very hot topic of tariffs. Today is March 4th, 2026, and we are providing you an update based on the most recent and latest information regarding this topic. I am joined today by my partner, Pedro Corona. Pedro Corona is the leader of our corporate and tax practice for Procopio, but based in Washington, D.C. Together, we run our tax policy group and our international tax practice, as well as corporate tax matters. Pedro, what will we be talking about today?
Thanks, Jorge, and it's great to be here. Yes, just as a recap, we'll be talking about the Supreme Court ruling that struck down the IEEPA tariffs a little more than 10 days ago. It seems like 2 months, but it has been only 10 days ago. Also, we'll be talking about some of the developments at the tariff level after the Supreme Court decision. And then mainly we'll be focusing our time on the issue of refunds. That is the main question. And also what can importers and companies do after this. So for starters, again, just as a recap, probably some of you have read some newsletters, some information, but what happened last year, President Trump declared a couple of national emergencies, one related to the influx of illegal drugs from Canada, Mexico, and China, another related to a trade deficit. After that, under IEEPA, after a national emergency was declared, he imposed some tariffs specifically to some countries. So after that, as you know by now, several companies challenged the validity of those tariffs, and it went all the way to the Supreme Court. So on February 20, it started in the Court of International Trade, also some disputes at the U.S. District Court. Both went to appeals, and eventually it went to the Supreme Court. Importantly, all the intermediate decisions, Supreme Court of Appeals, Court of International Trade, District Court, declared that the IEEPA tariffs were illegal. So that was already declared. So it was just some uncertainty of what would be the ruling on the Supreme Court, both on substance and second in procedure. The Supreme Court didn't address the procedure how to get refunds that we're going to be discussing later, but it ruled in a majority 6-3 that the IEEPA tariffs were illegal. Basically, that even though the IEEPA allowed the president to act in certain way and regulate foreign commerce, that authority to regulate did not include the authority to impose tariffs or taxes on imported goods. Basically, there were a couple of cases, as I was mentioning, one in the Court of International Trade, another in the District Court. Both went to appeals. Both were ruled in favor of the companies. But one issue that the Supreme Court made clear was that any dispute related to these tariffs has to be heard at the level of the Court of International Trade in New York. So that in that regard, we have some certainty about what's the proper forum to make requests related to IEEPA.
And Pedro, one comment to make on that point regarding the jurisdiction to oversee the trade cases is that this is a novel issue. The IEEPA provision has never been used to impose tariffs. And in fact, during Trump's first presidency, he thought about the idea, but it was never implemented. So neither IEEPA nor its predecessor provisions in the trade rules have ever been used for this purpose. So when Trump imposed these tariffs starting in April of 2025, importers, stakeholders, retailers did not know what was the proper vehicle to challenge his actions. And in a number of different cases, there were actions submitted against the Customs and Border Patrol. There were refund suits and legality suits filed at district courts in the DC circuit, as well as other courts, but also in the Court of International Trade. More of a belt and suspenders approach to make sure that if there was a forum to address these concerns, they would identify in this process which forum that would be. And fortunately, that is one of the good things that the Supreme Court decision did in its ruling. And I'll turn it back to you for this slide.
Yeah, and what was at issue was again if the if IEPA allowed the president that after declaring a national emergency to impose taxes on imported goods. I mean, one of the rulings of the statements of the Supreme Court was that tariffs are taxes, taxes on imported goods. So, but the issue is that IEPA did not mention taxes specifically. And where the administration was relying is the authority to regulate the importation of goods. So the main issue was whether regulate included imposed taxes, regulate by imposing taxes. And here, the pretty much the reasoning of the Supreme Court was that the constitutional authority to impose taxes is on Congress, and unless there's express delegation on certain cases, we cannot interpret that any other word means taxation. And also, there was some, as Jorge was mentioning, some reliance on the president that this law had never been used to impose taxes. And the previous presidents were very hesitant on relying on this to use it for taxation purposes. So again, the reasoning at the end was yes, taxation relies on the Congress. Congress knows how to delegate and knows how to make express concession on certain authority. It includes regulate in other laws, and in other laws, regulate doesn't mean taxation. So in this case, it was clear for the Supreme Court that the delegation of powers to regulate foreign commerce did not include taxation.
Pedro,
So
it's interesting to
yes,
read that decision because the government position was that regulate importation was necessarily linked, and you can skip over the 17 words or so that are in the middle. And the decision of the Supreme Court was if Congress had intended for the president to have that authority, they would have said tariffs, they would have said taxes, and they specifically did not include it. So they pushed very hard against the government's position that their interpretation that was so far away in that statute made sense. And it's interesting that while there was a 6-3 decision, which still means that 3 justices would have voted for the validity of the tariffs, the dissenting opinion didn't really get into the merits as to why that could be interpreted to give the president the authority. The dissenting opinion from Justice Kavanaugh basically said, if we had to issue refunds, it would be a very messy situation. As attorneys, as advisors, as people who are clients seek certainty, it is very hard to digest that because people want to know the reason why they're taking a decision, why they're not taking a decision, and that dissenting opinion basically lacks technical analysis regarding why he would have approved or supported the tariffs, other than some administrative matters related to the consequences of imposing an unconstitutional, unlawful tariff. So it's a good read if anyone out there wants to take a look. To their benefit, it's actually pretty easy to read.
yeah, and a couple of issues that were raised. Again, one, the administration was relying on the well, if I can regulate, like even prohibit the importation of certain goods, I could be able to authorize the importation with paying some taxes, right? I mean, that was the main argument of the administration, but it's not exactly reflected in the ruling. But when we heard the arguments, the oral arguments, is many of the justices were very hesitant on authorizing the president, the authority to impose taxes when with a simple national emergency declaration that it was not reviewable. So I guess that was part of the considerations of the justices. Anyway, moving forward, as also many of you know, after the Supreme Court ruling, again, it was only 10 days ago. It seems like a lot has passed since then, but after that, yeah, the administration announced that they would not be imposing the IEEPA tariffs anymore, effective Tuesday, February 24th, a little more than a week ago. But even though they should have stopped imposing them in the same day, right? But anyway, but after that, so the decision was Friday, February 20th. The IEEPA tariff stopped being applied on Tuesday, February 24th. But on Tuesday, February 24th, there were new tariffs being imposed under Section 122 that it allows the president temporary tariffs up to 150 days for 5 months, up to 15%. The formal order was to impose it at 10%. Yes, it was announced through social media that it would be 15%, but that has not been formalized. So right now it's 10%. There are different speculations about why was the reason, but I guess at this point nobody knows for sure except for the administration. But what we see right now is 10%. But that's not IEEPA. So, and just
And
as a
one
reminder,
thing,
yes, go ahead, Jorge.
one thing to note on this provision, Section 122, like IEEPA, well, IEEPA, the president did not have the authority. But as many of you may know, there are a number of provisions in the Trade Act or different trade acts that grant the government the authority to impose tariffs on foreign countries and foreign imports. However, many of those do require a report or some sort of work or product from one of the trade or commerce entities in the US. So Section 122 is one of the few exceptions that the president does not have to wait for a governing body in the commerce field or trade field to tell him this country is acting with bad behavior and then therefore you can impose tariffs. But the downside to that compared to the other provisions that it is limited. And then similar to what we're seeing with IEEPA, chances are, or there is speculation that these tariffs might also be challenged in the near future. And it is also unknown whether after the 150 days expire, the administration is going to try to again impose them under a different varying argument. But the fact is that there are not that many tools in the president's toolkit that he can use. And Section 122 is one of the ones that are least strong because it has a limited timeline and it does imply it applies globally. Therefore, you can't go after specific jurisdictions like China or Mexico, which he had targeted in prior efforts. So we'll see where this develops, but it is very important to understand or acknowledge that IEEPA stopped applying, and then we go into this new world. My understanding is that currently he has ordered the U.S. Commerce Department and the U.S. Trade Representatives to start looking into investigations for different countries. Those reports take some time, usually about a year or more. Sometimes they can expedite them, but the president is basically running out of tools that don't require consent or approval from either Congress or some other agency. And Pedro, maybe you can talk us through here some of the more common and known provisions in the trade world.
Yeah, I mean, we have the summary here but we have a couple 122 that is, again, a balance of payment deficit problem. That is the one that had been imposed after IEEPA since last week. But here, interestingly enough, I mean, there's a lot of uncertainty what is going to happen because at least initially a year ago, it wasn't a balance of payment deficit problem, it was a trade deficit problem, which is not the same in economics. So we'll see how that plays out. And as you mentioned, it's only for 150 days unless the Congress approves an extension. We know we're in a election year, so it would be hard to imagine that Congress is gonna express or make an opinion on that. But that's one option. Other is in certain cases of discrimination with Section 338, and then a couple that you mentioned that required some type of investigation or internal procedure before they're imposed. So right now we're in the world of Section 122, but again, there's a lot of uncertainty of what's going to happen. What we know right now, and that this is a good segue for the next part on refunds. What we know right now is that IEEPA tariffs are no longer applicable. The Supreme Court ruled that they're illegal. The Supreme Court did not pronounce about the proper procedure for refunds. But it make an expression that the proper forum to discuss any issue related to tariffs or this type of tariffs would be the Court of International Trade in New York. So, Jorge, what do we know about the refunds so far?
Well, Pedro, that is the billion-dollar question, and it's literally a billion-dollar question. Whether it's $130 billion or 170 billion, it depends on who you ask. But importers have paid roughly an estimated $170 billion in tariffs since April. And now with the decision of the Supreme Court, we're looking into potential refund alternatives. As you mentioned, the Supreme Court did not address the process with respect to which importers could potentially seek refunds or even further away, whether retailers who paid some sort of cost associated to the tariffs may be entitled to get an adjustment in some prices with their importers. But what we do know is that a significant number of taxes were imposed under IEEPA in the last few months. And one very important point to deliver to everyone on this webinar, there are a number of tariffs that the U.S. imposes currently, and not all of them are subject. Not all of them are under IEEPA. This means that if you had been paying tariffs under a different provision, those still will remain in effect. And in fact, many of those had been in effect prior to Trump's second administration. So when looking into the amount of IEEPA tariffs that you have paid, you need to look through the information, your CBP records, your entry logs, to determine which of those entries were subject to IEEPA taxes. In particular, we have seen already that retail has suffered a significantly larger share of the burden on the cost. Many of them import for Southeastern Asia countries, and Trump did assess the tariffs on those products. As you mentioned, the litigation at the Supreme Court level was remanded and sent back to the Court of International Trade. Potentially at that point, the Court of International will assess, with respect to the plaintiffs in those cases, what the proper mechanism will be to request a refund from Customs and Border Patrol. But in the meantime, anyone else who is not a plaintiff in that case needs to start evaluating what options they might have. And if we move over to slide 16, in the absence of specific guidance from the decision of the Supreme Court option, what we are left with is the current state of law. And the current state of law has two forms primarily that could be considered for processing a refund request. At the administrative level, import entries are recorded with the Customs and Border Patrol, and many of these are handled by brokers. So whether you're a broker on the call or an importer who works with a broker, these are typically registered by bill of lading, entry information, entry date, what tariffs are imposed. And they have an import date, and they also have several other dates that we'll get into momentarily. But in fact, that is your first option. Your first option could be whether to use existing mechanisms that, again, we'll talk about momentarily, to process those requests for refunds. But given the magnitude of the tariffs paid under the IEEPA taxes that were struck down, there is speculation that CBP might actually present a new form or procedure for these specific refunds. There is also the avenue that importers could also go to the Court of International Trade. And there is precedent in the Court of International Trade in which in 1998, the Supreme Court struck down a different tax. It was not a trade issue, but it was a different tax. However, there were approximately 4,000 cases, and the amount at stake was $750 million. And in that case, the Court of International Trade resolved the matter on behalf of all the plaintiffs, issuing refunds to everyone who was at stake. So there is no clear guidance as to what is going to happen and what the best process is, but there are two main forums, the CBP forum and the Court of International Trade forums. They are not mutually exclusive. And as you will see on the next slide, which I think, quite frankly, this might be, along with the next slide, the most important slides. So you have all been paying or potentially paying either directly or indirectly tariffs under IEEPA since April. When those imports subject to IEEPA have come into the US, they have been reported to CBP. This is very complicated, so I'm going to tell you very slow. CBP records each entry, and they process it in about 314 days. While that entry has not been liquidated, it constitutes what is called unliquidated. It has not been processed, it has not been finalized. And for all purposes for CBP, what you have paid is an estimated tariff or duty on those imports. In the event that you have any entries which have not been liquidated, and based on our analysis and the information we have seen already, most, if not all, of the entries subject to IEEPA may potentially be unliquidated. You could potentially file what's called a post-summary correction. This can be done by the broker. This could be done by the company. This could be done by external advisors if you don't have the capacity. But in effect, that post-summary correction must be submitted before the entry is liquidated. And in that CBP journal in your ACE portal, you should be able to extract a log of all your entries, identify which ones were subject to IEEPA, identify the import dates, and assess whether it's still unliquidated, and roughly speaking, estimate when it might become liquidated. In other words, any entries that have not been liquidated, you should, as quickly as possible, file a post-summary correction to adjust the entry, reduce the IEEPA tariffs, and say, no, we're not going to pay these tariffs because the Supreme Court held on February 20th that they were unlawful. If any of those entries become liquidated or the post-summary correction does not proceed for whatever reason, the entry becomes liquidated. It becomes a duty that has been assessed by Customs and Border Patrol, and then the strategy shifts to what's called a formal protest. And unlike other forms like the IRS, in which you have to file a detailed report making your case, this is also filed with the ACE portal, basically challenging the decision that the duties imposed on those entries was valid. The CBP, and that has to be done within 180 days from the liquidation date. And this is very important. If the entry becomes liquidated, let's say CBP liquidates an entry on January 15th, you have 180 days from that date to file your protest. Otherwise, CBP no longer has jurisdiction to attend your refund claim, and you will potentially lose your rights to a refund at that forum. However, there is another avenue. And as we have talked about, these are not mutually exclusive, but we can see on the next slide that there is also the option of going to the Court of International Trade. Potentially as a belt and suspenders approach, or also because entries were liquidated and you did not file a protest in a timely fashion. But if we follow through this flow chart, if you're the importer of record, then see and examine your log. You could potentially ask your broker for that. You might have access to your ACE portal, but you should pull a log with all your entries for 2025, 2026 that were subject to IEEPA. If the entries were liquidation or you're still within the protest period, file that post-summary correction, file a protest. If you did not have, if the entries are not within that scope and you have missed the window, which is unlikely at this stage, you should proceed to file a suit with the Court of International Trade. Again, not mutually exclusive. You could try to tackle the issue, preserve your rights with a refund at the CBP level, and you can also go to the Court of International Trade. Similarly, many of you might not actually be in the record of importer of record, but during the course of the year, you may have actually entered into negotiations with your suppliers to adjust your contract terms and your supply terms to share the cost or someone else to bear the burden of the duties. In those cases, it is very important to monitor the status of those refund claims. Definitely review your contracts, review any terms you may have subscribed to, review any discussions you may have had to see if the importer of record is legally bound to request a refund. And if they do secure a refund, how do you go and request that you be reimbursed for some or all the costs you incurred? And also to make sure that you are following the market. If now in this ever-changing landscape, other companies are changing their prices, modifying their pricing strategies or sales strategies, you might also want to see what they are doing and monitor it. But the big takeaway here is that these are not mutually exclusive. And if you're an importer of record or someone who has been bearing some of the burden of the tariffs, definitely the easiest potential way would be try to make the adjustment at the CBP level. If the entries are still in the unliquidated status, you can go for a post-summary correction. That is an administrative procedure that you can do on the ACE portal. If the entries have been liquidated, file a protest. Again, you have 180 days to do that. In addition to, or if you miss the deadlines for these matters at the CBP level, you should seriously consider filing a refund claim at the Court of International Trade. And what has happened since the decision? So since the decision dropped on February 20th, a number of refund claims have been filed in the Court of International Trade. As of earlier this week, there were over 2,000 lawsuits filed, some of them in the millions. One of them, I believe, or was reported, it's just for $2,200 in tariffs. So it is an effort that people are moving forward with. And in essence, it's because we don't know when this issue will be solved. And if you don't take these measures, there is a chance that the decision or ultimate outcome might happen after some statute of limitations have expired. So let's say the decision of the court says like anyone who paid the tariffs is now subject to reimbursement if they filed a valid claim. If you haven't filed a valid claim to preserve your rights, you might be booted off from that reward. Whereas folks who have tackled the refund approach at the CBP level, at the court level, will likely be included if a refund is issued in one of those forms. And there is speculation that several things could happen. Right now, the Court of International Trade is seeing just one case, the case that was remanded back from the Supreme Court. That case will potentially lead the outcome for the rest of the cases. And given that the Supreme Court has declared the IEEPA tariffs unconstitutional, this is not a factual question. This is like if you demonstrate, which is why documentation is important, that you paid the IEEPA tariffs, which were invalid, now you should be entitled to a refund. So if you file a refund claim in the Court of International Trade, there are several scenarios. Potentially, the decision in this case that's being heard right now will flow over to the other cases. In my opinion, less unlikely event based on the past precedent, the Court of International Trade might make each plaintiff litigate their case, which at that point we'll see how that happens, because there is a lot of money on the table and there are a lot of plaintiffs under these similar situations. So with that, Pedro, what happens next?
Yes, and just as a quick recap, as Jorge was explaining very well, is like what we're seeing is with clients, there are a couple of paths, right? Well, first they need to review their situation. Again, for the importers of record, what are the tariffs that they paid and the amount of them? And for the non-importers of record, if the negotiations that they enter with their U.S. customers, and if they accommodated somehow all the tariffs. I mean, we have some clients that reduce the price to try to be competitive. But for example, if they included a provision in the agreement to be in case of the tariffs were refunded, maybe they are able to request some economic compensation for the U.S. customers. So we'll have to see, but if not, at least on a going forward basis, that's something that we're advising clients to include in the future agreements. But if they're importing records, again, they need to review their file. Some clients have the resources to do it internally. Some clients are relying on the custom broker. Some clients have asked external advisors to do it because of the volume. But once they have the clarity, as you mentioned, Jorge, is okay. Sometimes is what some clients have been calling an amended tariff entry. So just to make sure, if it hasn't been processed, that it can be processed correctly. But if not, file a protest. That is an administrative procedure. And then see if they want to go through a belt and suspenders approach with a claim in the Court of International Trade. I mean, that's something, again, there's some uncertainty. Ideally, it's going to be clarified in the next few weeks, but also for the pronouncements of the administration, that is not going to be an easy process. So it wouldn't be surprising that we will need to get in the queue and make a line and file a claim with the Court of International Trade. But that's what we've been seeing right now. Again, there's a lot of uncertainty what's going to happen with the new tariffs, a lot of uncertainty what's going to happen with a refund. But what we know is what the law provides. That is, this is what we've been trying to explain. With that, we try to address the main questions that we had from clients. But Jorge, any final intake?
No, Pedro, thank you. Thank you so much for everyone joining us. I can't emphasize enough, proper documentation is key. We see it all the time. It's going to be easier to gather your information now than in 2 or 3 years when this unfolds, if it unfolds favorably. So be diligent, do it now. I know you're all busy, but it's important to get all those entries. You run businesses, you run your different endeavors. This is a good effort to do now, and seriously consider the different options because time is of the essence. Pedro, with that, I want to thank everyone for joining us, and we look forward to seeing you on the next webinar.
Thank you.